one of two things going to end up happening. You're going to end up breaking into somebody's place and they're going to be there and it's not going to end well for you, or either you're going to spend the rest of your life in prison.
3 felony charges, 1 defendant, and a plea deal already on the table: burglary, stolen card data, and serious prison exposure. The judge is about to decide if this deal stands or if Garcia risks something much worse.
Court is calling 2026 CR 002627, 2026 CR 002629, 2026 CR 002630, State versus Isidro Garcia. Can I have parties announced?
Representative for the state.
Orlando Castaneda for defense.
And are you Mr. Garcia?
Yes, ma'am.
Counsel, in each cause number, have you received all discovery and did you review it with your clients?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, Mr. Garcia, did you review the waiver of indictment reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes, Your Honor.
In each cause number, do you understand you have a right to have the grand jury review the state's evidence in this case and make a decision on whether or not there is sufficient evidence to hold you over for trial?
Yes, Your Honor.
And did you understand that your attorney has certain rights? Your attorney has the right to have the passage of 2 days upon presentation of the information and 10 days to prepare for trial?
Yes, ma'am.
Did you understand by entering this plea, you're giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived indictment reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In each cause number, did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
And defense, do you waive the reading?
I do, Judge.
State and the cause number ending in 27, are you proceeding on the information as presented?
No, Your Honor, we're proceeding on count 1, paragraph A, waiving paragraph B.
No,
Any
Judge.
objection?
No, Judge.
And in the cause number ending in 29, are you proceeding on the information as presented?
No, Your Honor, we're proceeding again on count 1, paragraph A, waived paragraph.
Again, no objection.
And in the cause number ending in 30, you're proceeding on the information as presented?
Yes, Your Honor.
In each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, sir.
In each cause number, I'm sorry, in the cause number ending in 27 and 29, you're charged with burglary of a building. And in the cause number ending in 30, you're charged with fraudulent possession of use or credit or debit card information, less than 5 items. Those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
All right. The cause numbers are, according to your plea bargain agreement, the cause numbers are to run concurrently. Your punishment is to be assessed at 18 months in the state jail facility. There are no applications. There's a $1,200 fine. And cause number ending in 30, the state is taking in consideration 2025 PF 48724. And the cause number ending in 29, there's to be restitution of $840.99 to Legend, Legend Homes, Homes. And the cause number ending in 27, the state is taking in consideration 2025 PF 48125. There's to be restitution of $861 to D.R. Horton. And that's to be mailed to 7515 Inner Circle Road, Suite 201, 78235 is the zip code. Did you understand that to be your plea in each of the cause numbers?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney in each cause number? Did you sign it?
Yes, ma'am.
All right, by signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Counsel, are there any such motions?
Good.
All right, outside the agreement in cause number ending in 30, there's to be no contact with Nathan Bain, Bain, Elias Bain, and Billy Ortiz, Ortiz. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then in the cause number ending in 27, paragraph A, how do you plead? Guilty, not guilty, or no contest?
Guilty, Judge.
And cause number ending in 29 to paragraph A, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
And cause number ending in 30, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Sheet offer states exhibit 1 and all attachments and all causes.
No objection, Judge.
All right, and state, have you spoken with the complainant?
Yes, sir.
All right, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And cause number 2026 CR 002627. Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing in that cause number?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, we just asked you to follow the agreement.
All right, in that cause number, the court is going to sentence you to 18 months in the state jail facility, give you credit for any time served, $1,200 fine. Time and money will run concurrently. This will run concurrent with 2026 CR 002630 and 2026 CR 002629. Taking consideration 2025 PF 48725. There's to be restitution of $861 to D.R. Horton. And that is to be mailed to 7515 Inner, INNER Circle Road, Suite 201. San Antonio, Texas 78235. There's to be no contact with Stephen Matthew Waligora, Waligora, Isidro. I'm sorry, that's a different Isidro. Anna Karen Lopez Castro. There's to be no residing in households with minors. And no unsupervised contact with minors. And that cause I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, next we're proceeding in 2026 CR 002630. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge.
All right, and outside the agreement with regards to the no contact, is there an issue with that?
I'm sorry, you're asking if there's an issue with the no contact?
Yes.
I don't believe he has any knowledge of who those individuals are.
All right, the court is going to sentence you to 18 months in the state jail facility. There's a $1,200 fine. Court will give you credit for any time served. This will run concurrent with 2026 CR 002627 and 2026 CR 002629. Take in consideration 2025 PF 48724. There's to be no residing in households with minors. No unsupervised contact with minors. There's to be no contact with Nathan Bain, Elias Bain, and Billy Ortiz. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. All right, next, we're proceeding in cause number 2026 CR 002629. All right, the court is going to find there's sufficient evidence to find you guilty of paragraph A, and the court will find you guilty of paragraph A. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge.
Court will sentence you to 18 months in the state jail facility, give you credit for any time served, $1,200 fine. This will run concurrent with 2026 CR 002630 and 2026 CR 002627. There's to be restitution of $840.99 to Legend Homes. There's to be no residing in households with minors. And there's to be no unsupervised contact with minors. Anything else with regards to sentencing?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You continue the way you're going, one or two things going to end up happening. You're going to end up breaking into somebody's place and they're going to be there and it's not going to end well for you. Or either you're going to spend the rest of your life in prison. And you got to ask yourself, these 18 months, was that worth the items that you were stealing? Yeah. All right, so you're going to have to make better choices. Good luck to you.
Thank you, Judge.
Thank you.
Morning, Judge.
Good morning. How's it going?
Pretty well, yourself?
Complain. It's going to be a beautiful day.
Outstanding, Your Honor.
So how's it been going?
We're going very well. We're going very well. Been able to catch my breath recently, so I'm not bouncing out of county so much anymore, so
Yeah,
I'm
I
more
hear you.
focused there.
Maybe we'll have one final trial with you guys.
Oh, well, we're trying.
And I'm just waiting. Odyssey is taking a while to load.
No worries, Judge. I
The
understand.
wheel is just spinning.
Well, I
Take your
spoke.
time, Your Honor. I understand.
Waiting, they don't have any of the documentation that they needed to provide to establish the restitution amount. So she's telling me they contacted the complaining witness, who's the one claiming it, and she's supposed to be here. She's talking to her advocate to see what their ETA is. Yeah, so I'll give you the heads up.
My gosh, I may have to, let me try this again because it's not doing anything. Just 1 second.
No worries, Judge. Having an Odyssey issue again.
Hold on, I know what's going on.
Okay, it keeps saying getting your case.
It needs it this time.
See, and you know what? One of the things that I say at every meeting, if this system crashes because we're going paperless, where is the information? And you know what answer I keep getting? Oh, that's not gonna happen. I'm like, okay,
Yeah, sure, sure. Famous last
I
words.
told everybody.
Yeah. I'm sorry, I missed number 2 pencils and Big Chief tablets.
All right, so on this case, we're here for restitution amount.
Yes, ma'am. I've spoken with the state. They don't have any paperwork to establish the amount of the restitution. So they're calling their complaining witness and she's supposed to be present, testify is my understanding.
Okay.
But I just spoke with the prosecutor and she says that she's in contact with her advocate to try to figure out what the ETA is on that complaining witness appearing before the court this morning. So we really can't do anything until she
Well, let
gets
me
here.
ask you this, state. I don't know if it's easier for the complainant to appear by Zoom or not, and if the defense would have any objections to her appearing by Zoom.
I just want the documentation.
All right,
Yeah, I can keep that. Here for her. We told her 9 AM, so I don't know if she's in the line or.
oh, okay, if you'll then see where she is, but if she's already here in line, then we'll just do it in person. All right.
Okay, and I just want to let the court know, I've got to go down real quick to the 437th. I will leave John Michaels here.
Wait, I've got an appearance I have to make too.
Well, you don't count, I do. No.
I tell you what, when they, just leave your information with Miss Ferguson and we'll call you when they come.
I appreciate you.
All right, thank you.
so
Have a
much.
good one.
Judge.
Thank you. Court is calling 2023 CR 2432 State versus Miguel Maldonado. Can I have parties announced?
Megan Galloway for the state.
David Andre Woodard from Mr. Maldonado.
And are you Mr. Maldonado?
Ma'am.
All right, defense has filed a motion requesting a bond. Defense, do you have any evidence to present to the court?
No, Your Honor.
All right, state any evidence?
No, Judge, we just asked him to judicial notice that the motion to remove that's filed and, the warrant that was issued.
All right, it appears that you all are requesting a bond of $60,000 or agreed to a bond of $60,000.
We're not, Judge. That's the state's request.
All right, so does anyone want to put any evidence on about flight risk, whether or not, what bond he can make?
Yes.
Thank you.
So,
Okay.
Basically, Judge, the case is a state jail felony that he's on probation for. And I believe he absconded maybe in February of 2024. Since then, he has reoffended on one misdemeanor charge, failure to ID. He has not reoffended on any other felony charges. I believe his original bond was $3,000, then it was raised for some reason to $6,000. We're asking the court to possibly set a bond at $7,500 in line with the charge that he's on probation for. And we would have no objection, Judge, to a, because of the non-reporting ELM, if the court would waive the fees.
All right, state.
the government offers everyone.
I don't want to misspeak, Judge, but I believe this is his first motion to revoke since he's been on this probation.
Yeah, I think it is as well.
Judge, since the offer states exhibit M1 for purposes of this year.
Any objection?
Okay. Thanks for inspection.
Judge, I have no objections to states M1, tendered to the court.
All right, State's Exhibit M1 will be admitted without objection. Any other evidence, state?
Just what is in file and that's that, and then has responded from the jurisdiction of this court since 2024. And that's the reason that you're requesting that you guys will house arrest.
Yes. Thank you.
All right, counsel, do you want to put on any evidence on the bond amount that he is able to make?
I would, Judge.
All right. Do you want to call him as a witness?
I will.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Miguel Maldonado,
All right, defense, you may proceed.
Miguel, how old are you?
that's 27.
Are you currently employed?
I was working part-time,
What kind of work are you
doing
doing?
roofing.
When I ask you a question, you gotta wait until I finish asking it, and then you answer it, because the court report is taken down what both of us say, okay? That way we don't talk over each other, all right? How much money were you making per week?
Probably anywhere from 600 to 700.
And we're asking the court to set a bond for you. I've requested that the court set a bond at $7,500. Do you think that's a bond amount you could make?
No, sir, I'm not.
What bond amount could you make?
I don't want to lie to you, so I believe they're local, but I gotta talk to my partner, my wife, because she's the one with the.
Okay, I'm so sorry. You're gonna have to, one, slow down. You're gonna have to speak up so the court reporter can hear and so that I can hear.
Okay, I'm sorry, ma'am.
That's okay.
I was gonna say, I don't know how much money we have left because my wife had gave the last 500 I have, so I gotta talk to her, consult with her to see how much she has, and then I'll be able to,
Well, we're here right now, so the judge needs to try to get an amount on what you can possibly make. That's the question to you.
they can't keep it at the 6,000?
Question to you is what amount could your family make? Just answer that question.
Or like a $500 bill?
We'll pass the witness, Judge.
I'm sorry, ma'am.
Oh,
That's
no
okay.
problem.
Just so I understand correctly, you said you need to consult with your wife to see the bond amount that you can make.
Yes,
Okay, so you personally have not reached out to any bond companies?
No, ma'am.
Okay, and at this point, you're unsure if your wife or any family members have done that, is that
yeah,
correct?
from my understanding, that was amended without bond.
Okay. We pass the witness.
All right, any?
No
further
redirect,
questions?
Judge.
All right, I just have a few questions and it's related to conditions to be set for bond. Have you ever been diagnosed in the past with any type of mental health issues?
Yes, ma'am. I got bipolar, PTSD, anxiety, and insomnia,
Okay.
and ADHD, my bad.
All right, in the past, have you ever used any type of drugs? And I'm not talking about while you've been on probation. I don't want to get into any facts of this, just in the past.
No, ma'am, just marijuana.
All right. The court has reviewed State's Exhibit M1. Any final argument before the court makes a decision?
We're just asking the court to set a reasonable bond, Judge.
All right. This is what the court will do. The court is going to set a bond. There's to be no contact with Christopher Martinez, Beto Hernandez, Eric Aric Arias, Amanda Inocencio, Inosencio, Daniel Ramos. There's to be partial GPS for medical treatment only. Waive GPS fees, GPS until further notice. And the court is going to set your bond at $30,000. And this is going to be set for a contested MTR in 10 days. Could I have 10-day reset for a contested MTR, please? I'm sorry, when? All right, is that good for you, counsel?
It is, Judge.
All right, so, and if you'll give the defendant a reset form, please? And say that, is that enough time for you?
Yes, sir.
All right, thank you. All right, you may be excused.
Final outcome. The judge rejects the state's $60,000 request, but still sets bond at $30,000 with GPS monitoring and strict no-contact conditions. Maldonado now waits for a contested motion to revoke hearing in 10 days. Like, share, comment, subscribe.
Yes, she's here. Hello.
Hello.
All right, oh, it was overcast. Is it no longer overcast?
All right, it's still ugly out.
Okay, well, now all weather is beautiful.
And,
It brings back memory when it was overcast when I was in school. We would play mathematics baseball.
oh, you're the brainiacs. Yeah,
We would love that.
I was playing Loteria.
All right. To the witness. And I'm sorry, what is her last name?
Ms. Dennis.
Dennis?
Hi, Miss Dennis.
Yes, ma'am.
This hearing was supposed to be concerning restitution. Do you have any documentation of restitution?
No, ma'am.
All right, and do you have any idea if you'll be able to get that documentation? And it's just,
I don't have it. I mean, within the last past 2.5 years, I mean, I have like been homeless, so I don't have anything. Like, I don't have none of the documentations or nothing like that.
okay,
None of these.
all right. So the attorney who is the attorney of record on this case is out of county. Are you able to appear by Zoom on a different day, and I'll take your testimony on the amount of restitution you feel you are owed. And then the court will make a ruling.
Yes, ma'am.
All right. And what I can tell you, if you had documentation, I believe the attorneys who are standing in, they would have been able to proceed. But because you don't have the documentation, the attorney of record is going to want to ask you questions.
Okay.
All right. So when is the attorney going to be available?
At the court's convenience.
All right. Are you all okay to do this tomorrow morning? All right, we're gonna, are you able, Ms. Dennis, to zoom in tomorrow morning? And we'll
Yes,
take your case up first thing?
Yes, ma'am.
All right, so we'll put you at 9 a.m. tomorrow morning, and it will be the same Zoom link that you have now.
Okay.
All right, thank you for your patience. It's appreciated.
And Judge,
Thank
just for
you.
the court's clarification, if Mr. Gonzalez is for whatever reason still stuck out of county, I will make myself available tomorrow and I will get up to speed. John and I will get up to speed over the evening so that we don't have to have another delay before the court.
All right, and before I get that date, Ms. Abrams, is that date good for probation?
Yes, Judge, it's fine. I would ask that, can the defendant appear via Zoom as well?
I have no objection to that if he can appear by Zoom, because that way you don't have to miss a whole day of
Yes.
work.
All right, we can have you appear by Zoom, okay?
Thank you.
And will your work schedule is,
Mornings, I have to take PTO today to come here.
Yeah, I don't want to have to miss another
I
thing
don't
of
want
work.
you to miss another day either.
Yeah,
So will you still need to take leave if it's by Zoom in the morning? Yes. I'm sorry?
I could do that.
you can do Zoom without having to miss work.
Well, I go in at 7 o'clock in the morning.
Okay, so this would be at 9 a.m. Could you take about a 30-minute break and not have to miss work and get clocked for that?
Yes, I can see.
Now, what I can tell both parties, if there's no objection, defense, you could waive his appearance.
I don't have, I will do this with a caveat that Leo may change his mind and want him here, so, but I will let the client know that. And I will let the court know that by this afternoon if we need to make Zoom appearance for him in the morning. But as of right now, I'm willing to waive his appearance tomorrow.
Okay. So just be in touch with your attorneys, but the court is not going to require you to be present. All right. Is there anything else?
None from the defense, Your Honor.
And what I can tell you, if the court rules that there's any type of restitution that is owed, probation and your attorneys will reach out to you and tell you the amount.
Okay.
All right. Is there anything else?
None from the defense, Your Honor.
All right. Thank you, Ms. Dennis.
Thank you so much.
All right. Bye-bye.
May we be
Bye-bye.
excused?
Yes.
Thank you. I appreciate you.
All right. You're welcome. You
Have a
guys
good
have a
one.
great one. You too.
So I appreciate you.
All right. Bye-bye.
Bye-bye, dear.
So the court is calling 2025 CR 007805-02, State versus Rafael Gonzalez Sanchez. Can I have parties announced for the record?
Rick Painter for the state of Texas.
Cesar Montalvo for Mr. Sanchez.
All right, state has filed a motion for continuance. State,
Your Honor, fortunately at this time with this particular case, there is as well a key witness who has been available to appear at trial this week. It is the detective on the case who is an essential witness, conducted a investigation, some evidence that needs to be entered for the trial. He is on approved leave this week since it is unavailable to come in and testify. State has acknowledged that this is the second trial setting of the case. However, the first one was set by Judge Angelini, who is covering for you. He is not at the requirement. Either myself or the defense is because I believe just picked another case that we wanted to do. So that one was reset by him to this date. Fortunately, as I mentioned, we have the material was unavailable to testify this week. But essentially, I request to you that this case can be reset to future trial.
all right. So my understanding from the notes that are in the system is that the case was previously reset to give defense counsel chance to view videos.
Oh, that's right.
Yes.
I apologize. I forgot.
Yeah. And I will tell you, that was in January. And then it was reset for jury trial on March 10th, which is today. So the motion for continuance will be denied. And if we have another case before him, if this case comes up, the court, of course, will give the state leave. We can start the jury trial, and then your witness can come testify next week.
Okay, Judge.
Thank you.
Oh, Judge, I guess we weren't expecting this motion to be filed. In light of that, we would also ask the court to at least, my client's on GPS monitoring, if I guess unless we get called today or until that next setting, if it would be available to either remove it or waive any fees associated.
Oh,
with that GPS.
yeah, the fees can be waived. Oh, I'm not removing GPS.
Thank you, Judge.
All right, thank you. Counsel, you're all proceeding on the MTR?
So Judge, just a quick update with regard to her matter.
Yes.
I have received an offer from the state to resolve her cases that includes the MTR and the new case.
Mhm.
At this time, it looks like I'm going to be selecting a jury in the 399th District Court. So they're expecting me to be in there to speak with the judge there about some pretrial motions. I wanted to see if we can reset this matter for sometime this week. I don't know when I would have someone have the ability to cover for me to enter into this agreement with the state on behalf of Ms. Ruiz. But I would foresee sometime this week if I can update the
All
court.
right, do you want to do it now? Do you want to do it within the week?
It would be foreseeably judged if we can get it done the week, because I need to speak with the judge in 399th, and then they're gonna excuse the judge for lunch, and I'm gonna be starting at 1 there.
Okay.
To begin trial. But it is something that we are looking to closing out for Ms. Ruiz. It's just my availability is a little limited.
No, that's fine. Do y'all want to call this back on Thursday, or you want it on Monday?
We can do Thursday, Your Honor. The trial I have foreseeably shouldn't take too long.
All right, Ms. Ferguson, this needs to be recalled for Thursday. All right, thank you. And we'll bring you back Thursday of this week. Do you have any questions about anything? All right, thank you. All right, so Mr. Hilliard, the last time you were here, the judge who was presiding, you stated that you wanted another attorney, and that judge denied it. However, your attorneys had a medical emergency. So Mr. Porter and Ms. Efron have been appointed to represent you. Do you understand?
Yes.
All right, so what ends up happening when attorneys are newly appointed? They don't have the information on your case. They want to make sure that they have everything. Do you understand? So I want to make sure that they have all the discovery. So that's where we are in your case. The state is going to make sure that they have the discovery. They'll have a chance to review it. And state, have you already previously tendered an offer?
Previously have, yes. I'm more than likely going to do a new offer to the attorneys.
Okay.
But yes.
right. So what I'm going to do, you all are going to have to confer off docket, because this is an old case by standards of the 187th. So I'm going to set it for a plea deadline date. And I'm going to set it for a plea deadline date in 45 days. Is that enough time for both parties?
It is.
And Mr. Hilliard, if they want to come back before that 45 day, all they have to do is let the court know, and we'll put you on the docket sooner. But this will give them the time to discuss with you. And I know, according to what's in the notes from the previous judge, there was some issues with communication. So I'm going to stress to you, these two attorneys, you need to communicate with them. You understand? And they will tell you in this court, if people decide not to communicate with their attorneys, then you will end up going to trial potentially without having communicated with them. You understand? And you have their contact information.
We'll make sure he has it.
All right. So what date, Ms. Ferguson?
That was on the 28th.
All right. So April 28th is going to be your plea deadline date. So in that court, what that means is on that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, there's going to be a quick turnaround for jury trial, And I will not accept any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. And your attorneys will explain that to you in greater detail. Do you have any questions? All right, anything else?
There you are.
All right, thank you all so much for taking on the case.
Ready to approach on Villasana.
All right, Villasana.
I apologize. I
Oh, no problem.
didn't have them on my calendar.
Let me just tell you, it happens. Been there, done that.
Thought you were calling me on the other two non-docket items.
All right, on this case, counsel, where are we on discovery?
There's a couple of body cameras they're still looking into. We should have them within the next 30 days.
All right. Ms. Ferguson. Your previous court date for the other person?
April 9th.
You want it on the same day?
That would be fantastic.
All right, Norma, if you'll put this on April 9th, and it's for discovery.
Sign this. Sorry.
All right. And state if there's a need for additional discovery date, because I know it's more than one case, just let the court know.
So this is just from last night, but I brought him here today because he understands. This.
So what happened?
Last night,
Well, yeah, because a judge issued a remand without bond because there's an issue with the GPS.
yeah, last night, they told me to come to the jailhouse. My mama, she had the kids. She was my only ride.
So what about was VIA not working?
Yeah, no, this was already past 10.
What time was it?
It's about going on 11 o'clock. And so,
Are you gonna have any objection to reinstating the bond?
Your Honor, at this point, we did speak with the pretrial services officer in charge of this defendant's monitoring device. He did inform us that the violation did occur while it was overnight staff. Their concern was he was in contact with them, but then he lost contact.
All right, so do you have any objection to reinstating the bond?
At this point, Your Honor, the state would just like him to admonish that he needs to remain in telephonic contact and keep his device in working order.
All right, so here's the thing. Number one, I can't reinstate the bond unless the bondsman is okay with reinstating the bond.
They are.
All right, so we're gonna go on the record. Court is calling 2025 PF 10207, State versus Dimitri Lavallee. Can I have parties announced?
Two Jones for the state.
Charles Bunk, Mr. Dimitri Lavallee.
And you, Mr. Lavallee?
yes, ma'am.
All right, it's the court's understanding that there was an issue with GPS. Is that correct, counsel?
Yes, Judge.
And is his GPS monitor currently working per pretrial services?
No, Judge, it has a red light on it.
He would need to
He
go.
needs to go and get that worked on.
All right. So state, do you have any objections to reinstating the bond?
Your Honor, the state would just like to admonish that it's when on contact to keep his GPS device in working order.
Okay, do you have any objection to reinstating the bond? All right, so the bond will be reinstated. And counsel, you inform the court that the bondsman has no objection to
That
the
is
bond
correct, Judge.
being
I spoke to them
reinstated.
this morning.
So the court will have the bond reinstated, recall the warrant. And you are to meet with your pretrial services officer today. Do you understand?
Your Honor, can we have him go straight from here to the pretrial services department? They are waiting for my call to see who is reinstated and what we expect.
All right, Mr. Blanc, if you'll call pretrial services and set up an appointment for your client to meet with the officer today.
Yes, Judge.
And do you have that number?
I believe we do somewhere, yes.
Okay.
It's on, I got.
All right,
a copy,
thank you.
Judge.
All right, thank you.
Thank you.
You're welcome.
You need a copy of the motion I filed that just basically says.
Oh, I have
Okay,
the motion.
okay.
All right. Court is calling 2025 CR 014342 and 2025 PF 33466, State versus Eddie Dacey. Can I have parties announced?
Ashley Jones for the state.
Charles Bunk on behalf of Mr. Dacey.
And are you Mr. Dacey?
Yes, ma'am.
All right, defense, you filed a motion to reinstate the bond in each of these cause number.
Yes, I did. Yes.
First question. Is the bondsman willing to, does the bondsman have any objection to the reinstatement of the bond?
They do not.
All right, then now let's address the issue with pretrial services. Counsel?
So Judge, as you can see from the violation report we've tendered to the court, this past weekend, there was a situation with Mr. Dacey's device. I'm sure the court knows, and I'll tender to the court if I can, I've showed this to the state for review. The messages, as you know, the agency contacts the client on text when they can regarding this issue. Those texts are an indication that Mr. Dacey got the text, was responding and tried as he could. It said, go inside, go outside. He did that. He went to the South Tower. They told him to come to the South Tower and somebody would get to him there. He went there and waited over an hour. Nobody came to him. So he went back home, but he understands that, he's not looking for trouble. He had this problem. He tried to fix it on his own. He did what they told him to do, go back inside, unplug it, replug it. But it didn't, it's working now.
I guess they don't, the response you are.
All right, so
I would recommend that we send him to his officer to pretrial today to verify. The state, as I understand, was not able to contact this particular officer.
We were not, Your Honor.
all right, do you have any objections to reinstatement of the bond?
Yes, Your Honor, we do, just based on the facts, the egregiousness of the case, specifically the Plea case, the state would object to reinstating.
All right, did you have a chance to read defense's text messages?
I sure did, Your Honor, where the state has an issue and I was not able to verify anything because I could not reach my services officer.
All right, the court is going to note for the record that the defense has presented text messages to the court showing that the defendant, Mr. Dacey, tried to address the issue with regards to any type of malfunction with the GPS device. The court is going to ask that the court warrant be recalled. The court is going to ask that the bond be reinstated and you to report to pretrial services today.
Yes, ma'am.
All right, and counsel, do you have the?
I do, Judge. I'll need that, if I can get that back from you. Okay, thank you.
All right, thank you.
Thank you, ma'am.
Thank you.
Thank you, Judge.
All right, the court is calling 2023 CR 1197, State versus Joaquin Mendez. Could I have parties announced?
Megan Galloway for state.
Robert Featherston representing Mr. Mendez.
And are you Mr. Mendez? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor. We did.
Court will find that the state is in compliance with discovery. Mr. Mendez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
We do.
State, are you proceeding on the indictment as presented?
Judge, we are waiving count 1, proceeding on count 2, and waiving the first punishment and commencement and proceeding on the repeat offender enhancement.
Any objection?
No objection, Your Honor.
All right. And so that would be the burglary of the habitation that you're proceeding on?
Yes.
Okay. All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? This one's. All right, off the record for a moment. I do need the magnifying glasses. All right, that's correct then, State.
I shouldn't be throwing stones, though. There's plenty of mistakes you find that I make.
Well, you know what? It's so funny. My glasses are for distance, so they're not for reading. So I have to take them off to see it. All right. So did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right. You're charged with deadly conduct firearm as a repeater. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Mendez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right. All right, did you review the plea bargain page with your attorney? Did you understand it? According to the plea, you're proceeding on count 2 only. You'd agree that you've been previously convicted of a felony for enhancement purposes. Punishment is to be assessed at 15 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. There are no applications. This will run concurrent with 522 CR 00670 OLG. And the state will take in consideration 2023 CR 1198. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest? To the enhancement paragraph related to the burglary of a habitation force repeater, to that, how do you plead? True or not true? State any evidence.
State offer states 1 in attachments.
No objection, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consent to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Counsel, do you wish to proceed with sentencing?
We do, Your Honor.
All right, and state you may be excused. Anything you wish to say on behalf of your client?
Your Honor, we are respectfully asking this honorable court to follow the plea.
All right, the court will sentence you to 15 years in the prison. Give you credit for any time served. Take in consideration 2023 CR 1198. This is the run concurrently with 5:22 CR 00670 OLG. There's a $2,000 fine. Time and money will run concurrently. There's an affirmative finding of deadly weapon. There's to be no residing in households with minors. There's to be no unsupervised contact with minors. And
Your Honor, may I address the court?
yes,
Judge, when we're finished here, Mr. Mendez is gonna go back into federal custody.
Mhm.
He'll be there for 20 years. With the court's current order, the BOP is not going to allow his children to visit him at the BOP. The court considered that in making the decision about minors.
based upon what I read in the police report, no. All right, and there's to be no contact with Mary Ann Velasquez. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? And Mr. Mendez, I want to let you know, we're off the record, that I did, it may have seemed that my answer was very quick to your attorney. But mentally, I was already thinking about it. And the reason why I did that is based upon what I read in the police report. So of course, at some point in time, if there are any mental issues that are going on with you, any inability to control yourself, once you take some courses, which I recommend while you're in custody, figure out where all your anger is coming from and address that. All right? Okay, good luck to you. Thank you, counsel.
Thank you, Your Honor.
Final outcome. Mendez accepts the plea deal and receives 15 years in prison with a deadly weapon finding and a $2,000 fine. The sentence runs concurrently with another case, while additional charges are taken into consideration. Like, share, comment, subscribe.